Now I recognize the gentleman just joining our subcommittee from Minnesota, Mr. Lewis. Welcome.
Thank you, Mr. Chairman, and thank you to all of the witnesses here today. Certainly data and facts do matter, and I think if we look in a somewhat objective way over the last few years of the NLRB, what we see is an activism that's got a lot of people a little bit concerned. I certainly support collective bargaining, especially in the private sector. Certainly support the rights of people to organize. But if you take a look at what's happened with the joint employer standard, where you're trying to get someone, a franchisor who's not responsible for payroll, to be part of a collective bargaining unit, strikes a lot of people as a stretch. If you look at the micro unions, when you could take it to the extreme and one person is going to be a union now in order to organize. If you take a look at the free speech concerns on these ambush election rules, if you take a look at a company, a large airline manufacturer, relocating a plant, and all of a sudden that's an unfair labor practice. And finally, of course, the reason that this activism, I suppose, on our side of the aisle anyway, is concerning or disconcerting is it had to be done, or was tried to be done, through the recess appointments, which the court had to intervene on. So I think if you look at the data and the facts, it's pretty clear there's been something going on at the board. And I would ask Mr. Larkin to perhaps comment on what might be the ultimate, if you want to call it activism or ultimate end game here, and that is the end of a secret ballot, card check for everyone. It's very concerning to me because that is at the essence of not only our constitutional governance, but philosophically, the idea of the absence of coercion in any form of election is key. Is it not?
Yes, and prior Congresses tried and failed to amend the National Labor Relations Act to remove the secret ballot. Another thing I suppose that I could add to that comment on card check is, if you look at the joint employer standard, in addition to all of the uncertainty and confusion and chaos that's caused businesses like Ms. Alul's based on the legal standard itself, there's more going on beneath the surface of that whole debate. The new joint employer standard, in my view, has nothing to do with the facts of that case or joint employer in the temporary staffing industry. It is about a need for a change in the law on the side of organized labor to unionize from the top down in the franchising industry. We've all seen Fight for 15, and I'm not here to pass judgment on whether workers deserve $15 an hour. But what's beneath the surface of that movement is an effort to organize in retail and fast food. It's illegal under the National Labor Relations Act.
Thank you. Mr. Lajeunesse, you mentioned back in the private sector, of course, Hudson, and the public sector with regard to First Amendment rights. And I want to elaborate or get your take on that. In Minnesota, we've got personal care assistants who are having dues taken out of their paycheck, and sometimes they're not aware of it. It's certainly been a card check type method of organizing there on some of these home health care workers and that sort of thing, notwithstanding Quinn. But if you look at back in Hudson, could you elaborate a little bit on getting around that First Amendment protection with agency fees and what those levels are and what they should be?
I'm not sure I understand your question.
Well, for instance, in my home state, you don't have to join the union, obviously. You have a right to join or not join in many cases. But you do have to pay for agency costs, collective bargaining costs. The problem becomes when those collective bargaining costs become so exorbitant, being 60, 70, 80% of the dues, why not join?
Well, that's the incentive that employees have. The problem, of course, is who determines what percentage is chargeable to the objecting non-member. It's the union. Right. And the records are very complex. And the board has done a lousy job in protecting the rights of private sector employees who object to the use of their forced fees for political and other non-bargaining purposes, as I pointed out in my testimony. And the solution to that, I see, is the passage of a national right to work law, sponsored by your colleague, Mr. Wilson, from South Carolina, which would take that matter out of the hands of the board and put it in the hands of the individual employee who could decide whether he wants to voluntarily join the union or not.
I thank you for your testimony, as I do all the witnesses. I yield my back.